good evening. I will not take too much time. I'm sure that you've heard many things, and it's maybe absorption rate is being reached here, so I'll try to be brief. I'd just like to point out that I started as a labor lawyer, and I specialize in employment law as well, and I'm going to be speaking about that subject today. Okay, so I guess the place to begin with employment law is that it's complicated. And it's very easy to make mistakes and get yourself into lots of trouble. And there's usually fairly severe penalties if we do make those mistakes. And of course, we live in a world where everybody happily adds to our burdens and passes new laws quite often that impose new requirements. And so what can we do about that? Well, I always start off by talking about business in general, because business is the art of taking risks. And ultimately, there's an upside to that risk, but there's also a downside. And the downside is often where you fail to understand the legal requirements that apply to your business, especially when it comes to your employees. That's going to get you into trouble. And it can also be expensive. So first thing is to know the risks. What are we talking about? We're talking about wage and hour law, we're talking about workplace harassment, we're talking about many things, many themes that you'll see frequently in the newspapers, and they do affect you in a way that's very graphic. So our job as business people is how do we hedge or mitigate those risks? Okay, first and foremost, we want to comply with the law. Okay, that's pretty basic, but a lot harder to do than it is to say. We want to shield the business owner from liability, okay? And there are many ways of doing that, but the basics are an adoption of a business organization that limits liability by contract and also by insurance. You get insurance, and hopefully, if you realize that risk, you're going to be able to hedge it. Okay. So what are the mistakes that we often see employers making? One of them is the failure to maintain records. So for example, when it comes to wage and hour law, if you have a non-exempt employee, it is your duty to keep track of all hours worked. If you fail to do that, then the Department of Labor is simply going to take the employee's word as to how many hours they worked. I recently had a case like this in which an employer misclassified a truck driver as being exempt. And the truck driver filed a complaint with the wage and hour, and they said, well, how many hours did you work? And he said, I worked 66.5 hours a week. And you know what? They awarded him the award on that basis because the employer had failed to keep track of the time records because they thought they were exempt. Okay? So those kinds of mistakes can be expensive. Also, sometimes you'll get a claim from an employee. Let's say, for example, hopefully you have a workplace harassment policy, and an employee comes to you and says, somebody's doing something to me, I think it's in violation of the policy. And you fail to investigate that complaint. Well, I can tell you that that's the kind of thing that's going to cause punitive damages to be awarded if you get sued. Okay, compensatory damages is one thing. Punitive damages are intended to punish. They often amount to millions of dollars, and there's no insurance for it, at least in many states. So, not a good thing. And the failure to stay on top of things, okay? Laws are changing every day. Okay, I just saw today, for example, that the Social Security wage base took a quantum leap today, it was announced, by over $8,000. The biggest increase in any one year to another in the history of Social Security. And I can go down a long list of laws that change. And of course, deferring compliance until it's too late. We always say, mañana, you know, we're going to get around to doing this, whatever that may be. But we find too often that it's too late. Okay, so one of the most common ways that I see a lawsuit starting or an investigation is you've terminated an employee. And that employee goes marching down to some agency and says that you've done something wrong. So one of the things I always say to employers, before you do that, unless they've done something bad, really bad, maybe you should take a time out and just ask one very simple question. Why am I terminating this person? Okay? And you better have a good answer for that, because it's a little complicated in today's employment world. But I can tell you this. If you say it's for this reason, whatever that reason may be, hopefully your personnel records are going to back that up. And the actions that you've taken have been consistent with that. So if you say, this was a terrible employee, they were absolutely awful, and they didn't do anything right, and now they subpoena your records, and you have job reviews where the person is lauded for their great performance, and you've given them increases year after year, I'm going to tell you something. You're going to have a problem. Okay, so it's very important that you look at this and maybe act, in a deliberate way, and not just terminate somebody without realizing that, in fact, this could get you into a lot of trouble. So ultimately, what does at-will employment mean in today's world? Well, in many states, we say you have at-will employment. But the truth of the matter is, although you could terminate anybody for any reason, except the wrong reason. And the wrong reason is a long list. All you have to do is go to your state law, look at their law against discrimination, and you're going to see a very long list. And if you don't give that employee a good reason for why you've terminated them, you're going to allow them to speculate on what is the wrong reason for their termination. Okay? So employment at will really is a fiction at this point. Okay, so when we get into wage and hour law, I'd say probably one of the biggest areas of non-compliance there is. And serious mistakes are made in this respect. So don't feel like you're being singled out. The truth of the matter is, I tell any employer I could go in, I'm going to find mistakes because they're made every day. And so the question is, how much is that going to cost you if in fact it comes to light? Now here's the bad news. Usually when an employer makes a mistake, they make it for everybody. Okay? Which then gives rise to something else called a collective action. And what that simply means is, I'm sure you've heard the term class action. Class actions are somewhat hard to maintain. Okay? You have to get a class certified, and it's not easy. However, a collective action is much easier, and it's specifically designed for wage and hour cases. So if you've done the wrong thing and you have 100 employees, and let's say you owe that one employee $1,000, now you got $100,000 that you have to worry about. And that's the way it works. Okay, so what are the damages? If you improperly pay an employee and then you do not follow the wage and hour law requirements, here's how it works. First, they can go back 3 years. They actually could go back 2, but they can add a third if it's intentional. And if you have failed to consult with a lawyer and get an opinion, and what you're doing is proper, it's going to be deemed to be intentional. So they go back 3 years. Then they're going to double that. That's the penalty. Then you have fee shifting. Now, fee shifting is something you should all fear, because what it is an invitation for a lawyer to sue you. And ultimately, the lawyer is going to sue you, and if they succeed, and of course, if it's a wage and hour case, they know whether or not you violated the law. So they start their lawsuit, they know they're going to succeed. The only question is going to be whether you have enough money to pay them. Okay? And so you get to pay the lawyer's fees, and the penalty, and 3 years going back. And now, if it's a collective action and you have those 100 employees, that's a lot of money. And unfortunately for you, you can't even get insurance for it, because as a matter of public policy, you as an employer have to pay your employees what you owe them. Nobody else can do that for you. Okay, so we got to get into some of the basics of wage and hour law. One of them is, what is the work week? You must define the work week. What is the rate of hourly pay? Okay? You must tell the employee, this is your rate. And I'm going to tell you something. I'm going to skip ahead because I'm going to try to get through this quickly. I wish I had the time, but ultimately, many times employers will say, you're on a salary. I'm going to pay you $400 a week, and they think they've done their job, except that's not the way it works. If they're exempt, no, not exempt, then you have to pay them overtime. So they're going to take that $400 and divide it by 40. That's going to be $10 an hour. That's going to be the rate. And if you've been paying them $400, but they've been working 50 hours a week, you're going to owe them a bunch of money. And also, this is a very important question in today's society, what is compensable time worked? Okay, so we know that in traditional situations, people come to the job, they punch in, they do their work, at the end of the day, they punch out and they go home. Okay, but we don't live in that kind of world anymore. Now we live in a world with the internet, you know, working remotely, cell phones, you know, so on and so forth. The workday doesn't really end in many cases. And you as an employer, you have to keep track of their hours worked. That's your job. Okay, so ultimately when you give somebody a computer and say, oh, you can work at home, we don't have enough room for you in our office, well, please work from home. And the employee, when they get fired, goes down to the Wage and Hour Bureau and says, I worked 80 hours a week. And you don't have any record because you didn't have a time clock in their house. Okay? Or you didn't have them log in on a computerized system. Well, they're going to take them for their word. Okay, so we talked about the damages. First thing first is you must identify, is this employee exempt or non-exempt? That's a very important question to answer because it goes to whether or not you have to pay them overtime. Okay? And we know, I'm told at least, that you've had recent speeches or speakers on the change in the minimum wage or salary for white-collar exemptions. So I'm not going to bog down on that. But as I said, what are you doing if they're working remotely? Okay, so we know December 1, the white-collar exemptions are going to change. I'm going to try to buzz through this very quickly, but let me just remind you, there are two requirements for all white-collar exemptions. You must pay them a wage, a salary, that is at least going as of December 1st will be $913 a week, and the second is the duties test. There's two tests, not one. A lot of people say, oh, they're salary. No, that's not the answer. That's half of the answer. Okay, so if you'll just bear with me. And by the way, this is an important question to ask and answer is, how is this change going to impact on your operation? And why are job descriptions so important? Because you can write a job description that's keyed into the exemption and make your case so that when you get an audit, you can produce a job description and prove to, hopefully, to the investigator, we're complying with the law. This person is exempt. Here are the requirements. We lay them out, we give them the required wage, and they're okay. So now I'm just going to try to go through this. Unfortunately, this was all done with the thought that I was going to be doing a lot more of this. So let me just try to get through this. By the way, I'm just scrolling through just a comment on the executive exemption and administrative, because those are the two most common that you're going to see, probably in your situation. Okay, so one thing I want to note is the salary, this 913 is going to be updated every 3 years. In 2020, you'll get another change in that. Also, the duties have not been updated, but I wouldn't put it past this present government to come out with a new duties test. Okay, so what are the actions that you should do? First is, who's going to be exempt, who's not going to be exempt? You should be identifying that. And now, you may have to reconfigure how these people, how they work and how they're paid. Okay, so basic question, what is the rate of pay going to be? Okay, if you can't afford to make this person exempt anymore because you can't raise them to $913 a week, then you're going to have to come back into a rate of pay. How many hours do they typically work? If they typically worked 50 hours a week and you were paying them X, you can divide 50, factoring in the overtime rate that you're going to have to pay. You can come up with an hourly rate. And maybe that'll all work. But the only downside is if you reclassify the employee, first of all, people take pride in the fact that I'm a white-collar worker, I'm exempt, I get a salary, etc. Now you have to tell them the bad news, you're really not exempt, and now you're really making $12.50. It doesn't make them feel good. But bottom line is it really doesn't have to cost you anything extra if you at least think it out and try to plan it. And also, let's understand one thing. If that person is not exempt, you have to keep track of their time. Okay, so you have to really look at what you're doing in terms of timekeeping. Okay, one of the things we're seeing in our employment mix here today, in this present world that we live in, is the concept of joint employer. You're seeing that. I saw that. I had a nasty case this summer with the Department of Labor involving a franchise. And believe it or not, they were contending that the franchisees were the franchisor's employees. And we have an administrative opinion by the U.S. Department of Labor, which is a very scary thing. So it is not an easy answer to answer anymore. And also, of course, we all know that independent contractors is a very hot topic for our wage and hour and everything else. And misclassification of employees can be a very expensive mistake. Okay, and also, let's always remember one thing about any kind of employment law. Who's the sovereign? We know we have the federal government. They set the minimum generally for anything involving interstate commerce. Then we have state laws. Now we have more and more, we have cities imposing laws. Go to New York City, you'll see a very happy situation where they have every requirement imaginable that they impose on employers in the city of New York. But you're seeing that in many others. And there are a lot of common themes. What are we talking about? Living wage, paid time off, changing employees' work schedules. These are very popular items that all these little cities that have nothing better to do are passing laws about. So you might have the pleasure of answering the three sovereigns. Okay, so I mentioned that salaried employees, cash payments, not a good idea. I'll say nothing more than that. Tipped employees, lots of mistakes in tipped employees. I'm not going to bog down on these, but I often point out that you take Starbucks, big company, right? Very successful company. They got nailed for a $102 million judgment in the state of California alone for blowing tip pooling rules, okay? Tip pooling rules are not that complicated, but you have to know what the rules are because there's no flexibility. And if you make a mistake, then you now have, instead of a tipped employee, you have a minimum wage worker, and that's going to cost you a lot of money. Okay, and you should have a written tip pool policy, and you get everybody to sign off on it if you have tipped employees. Okay. And by the way, sharing tips with a supervisor, which is what Starbucks sin was, is a costly one. Okay, and also performance of non-tip work. And this isn't just tip workers, it's also any white-collar exemption. If you have an employee doing 20% or more of their time doing anything that's off that chart, then you're going to blow that whatever that requirement is. So if it's a tipped employee, if they spend more than 20% of their time doing the setups and cleaning up and everything else like that, you're going to have a problem with the Wage and Hour Bureau. The imposition of a service charge, that's not a tip. Tip by definition is a voluntary payment directly from the patron to the server. I told you about misclassification of employees, and by the way, if you have any kind of ERISA plan, you can get Microsoft paid $900 million for misclassification of its independent contractors. And of course, we know that there's a lot of schizophrenia when it comes to immigration law. I don't know what gets enforced anymore. It's hard to say. Employee posters, believe it or not, you can get fined $17,000 for not having a poster up. Okay, and keep in mind, we talked about mitigating risk and protecting yourself from risk. Just understand, in some instances, you fail to do something that the law requires. Even if you have a corporation, you're going to be personally liable. And number one on that list is wage and hour law. You don't pay the employees in accordance with the wage and hour law, you will be personally liable for that. So it's very important that you know what to do and comply. Okay, another good idea, insurance. I talked about at the beginning, employment practice insurance, very good idea. However, when it comes to wage and hour law, it may provide some means of your defense, but it's not going to pay your damages. And, of course, we have workplace harassment, sexual harassment. There are requirements. You have to have a policy, you must communicate it, you must train your supervisors, And you must make employees very well aware of the fact that they have an opportunity to complain about this. If you don't do these things, you'll have no defense, it's strict liability. And have you done everything else? Well, that's a good question. I'm going to stop right here because I know that you're probably tired. But thank you for listening. I appreciate your attention.